Good afternoon, Advocate Davis.
Good afternoon, Chief Justice. You're a long way away.
Are you relaxed or just like some of us, a bit nervous? I was nervous every time I came to be interviewed. Are you comfortable? Are you relaxed?
Well, as you know, Chief Justice, this is my third interview, so if I'm not relaxed now, I'll never be.
Okay.
I'm okay.
All right, okay. Just in your own words, and I'm not going to try and ease you in view of your answer. You are silk. You've acted, you've been here before, you have a better understanding of the challenges and needs of the Western Cape Division of the High Court and what difference you could make. Just in your own words, just brag. Don't brag a bit. Brag as much as you consider it necessary to get this one of the posts. I leave it up to you.
Well, thank you for giving me that opportunity, Chief Justice. And I want to start by saying that in terms of temperament, it is very difficult for me to brag. I was raised in a Christian household where the virtue of modesty was drummed into me, and where my parents, they are such down-to-earth, humble people that bragging and selling yourself was anathema to them. So I would like the Commission to understand that it is difficult for me to sell myself. But since you've made the invitation, I'm going to do so. I would like to ask the Commission to consider appointing me for a number of reasons. The first reason is that I have a demonstrated track record as an acting judge. I have cumulatively acted for 3 years, for 1 year between 2012 and 2013, and now for 2 years from October 2017 until now, and I'll be acting again this term. And you can see, if you look, I would submit, if you look at the judgments I've written, particularly in the last 2 years, I would submit that you see there a demonstrated ability to do the job. And I would further argue with respect that you see in my judgments a great commitment to the values of the Constitution, referring particularly there to the judgment of R versus Cruz, which dealt with the rights of a hearing impaired accused. So, moving on from a demonstrated ability, I would respectfully submit to this Commission that I have the temperament to be a judge. I'm patient, I'm humble, I have an open mind, and I seek always to find the truth. I'm diligent, I'm hardworking. Moving on from that, I believe that I have the right mindset, the right attitude. I believe in the values of the Constitution and the rule of law. I'm passionate about them. I'm committed to enforcing them and implementing them and interpreting laws in a way that promotes the values of the Constitution. And more than that, I passionately believe that the judiciary should be founded on a culture of service. That, I think, is at the core of my calling to be a judge, is that I want to put forward for service to the people of this country whatever God-given talents I may have. And then lastly, and by no means least, there's the question of fit. I believe that I fit in well in my division. I have a deep sense of belonging with my colleagues. I've become very attached to them over the last 2 years. And so I believe I'm collegial, I foster collegiality, I'm respectful, I'm courteous, I'm helpful, I'm cheerful, and I'm encouraging. I think they like having me around. And I think that's quite an important thing too, because I think fit is an important thing in any organization. So I've gone on at some length about myself, but I think those points encapsulate why I would submit that I would be an enhancement to the division which I seek to be appointed to.
One of the most embarrassing developments in the in the judiciary has been delays in delivering judgments. I mean, going through one of the reports of the Judicial Conduct Tribunal, I was shocked to see that there was a judgment that has remained unwritten for 10 years. So, what is the longest that has embarrassed you in this regard? How long did you take to write a judgment to the point where you were embarrassed?
Chief Justice, if I stand under correction, I don't believe I've ever taken longer than 3 months. There's one matter at the moment which is outstanding, but it's a full bench appeal where my senior judge has indicated that she wants to write the judgment, and so I'm waiting. But in my own matters, I don't believe that I've ever taken longer than 3 months. And I work very, very hard at not doing so. In fact, ordinarily, my turnaround time is about 3 weeks. And I work hard to make it so. I don't think I could sleep at night if I had a judgment outstanding of longer than 3 months, and I would do whatever it took to make it happen. I feel very strongly about that.
JP?
Thank you, Chief Justice. I have just 2 questions for this candidate.
If you could pull it closer, that mic is not too friendly. If you could put it closer and put it on the side you face when you speak.
Thank you, Chief Justice. Thank you. Just 2 questions for this candidate. What is your understanding of the doctrine of separation of powers?
Thank you, Judge President. My understanding, in a nutshell, is that the doctrine or principle of the separation of powers endorses that there are 3 separate branches of government: the legislative, the executive, the judiciary. They each have their own functions, their own spheres of competence, and they must keep to those spheres of competence and mustn't intrude into the arenas of the other. I like to think of it like 3 lanes of traffic on a highway. If you keep to your lane, all well and good. You stray into somebody else's lane, you're going to make an accident. And so it is with the separation of powers. In particular, judges must know the limits of their power and not stray into the domain of the executive and the legislature.
One last question, Chief Justice. Is there racism in the profession? I'm talking about the profession, in the legal profession, and the Cape Bar in particular?
Unfortunately, I have to say yes. It takes many forms, it's insidious, and I think it's going to take years to stamp it out. It's not to say that we're not making small steps forward, but it's still there. And I think the legacy of apartheid is going to take many generations to undo. And when I look at the statistics of the Cape Bar, I realize how slow transformation is, and that tells me that we've got a very long way to go.
Have you done anything to assist practitioners coming from previously disadvantaged backgrounds to ensure that they settle well in the profession? Have you done anything to help them?
I have, Chief Justice, if I can answer that question, on 3 levels. One is that right from the beginning, when I qualified as a practitioner, the year after that, in 2002, I became involved in legal professional education, because I really felt at that stage that transfer of skill and sharing of knowledge was going to be important in the future of this country. So that I've been involved in professional legal education in one way or another for about 20 years. Then on a level closer to home, in the last 2 years before I came to ACT, I involved myself in initiatives of the Cape Bar where senior practitioners would bring on board a black junior on a fee-sharing basis so that you teach them, mentor them, expose them to work, and also get them to earn some income. So, for instance, I had a matter where I was on brief for the Bito municipality, and costs were very sensitive, so I said to them, okay, you don't want to pay for a junior, but I will pay the junior out of my fee. Can I bring her on board? And they said, oh, absolutely. So that was a way of involving her. Another matter, similarly cost sensitive, I involved a black male junior, and I sat him down the afternoon before court and went through the papers and said, this is how we're going to present the case, this is how we're going to argue the case. It wasn't just a box-ticking exercise. I took the time to teach him, to mentor him, and I could see that he really learned something from the exercise. So I've been involved in things like that. Informally, I have a colleague, and he said I could mention his name. I have a colleague on my floor called Charles Simon, who I have informally mentored for many, many years. Charles has had the free use of my library. He's come to me. There was even a time when he came to me and said, there's no money in this brief, but I'd like you to lead me. So I said, fine, I'll lead you pro bono. So I've done my bit within the limits of the resources at my disposal. So yes, that was the answer to your question. I think 2 levels. Oh wait, yes, no, that was it.
Thank you, Chief Justice.
Thank you, JP. Ms. Stewart?
Thanks, Chief Justice. Advocate Davis, the General Bar Council has made comments on each of the candidates, and I'm interested in one of the comments that they made, that you had assisted them in reforming the Silk application in 2016. And according to their comments on you, you argued that recognition should be afforded to a greater range of skills, and that emphasis should be placed on the demonstrated competence of candidates with reference to a clearly articulated set of competencies. I'm just interested to know what you meant by the greater range of skills that you suggested should be recognized in the Silk application.
Well, for example, one of the skills that was overlooked at the time and which I argued should be recognized was mediation. I could already see at that stage that mediation was becoming increasingly important in our profession, and it seemed to me all wrong that there was no recognition towards Silk of a candidate's skill and experience in mediation. So that was the one competency that I argued should be recognized. Another was the move away from focus solely on oral advocacy to take into account competence in written advocacy, because long before a matter gets to court to be argued, papers are prepared, and a lot of the work of an advocate is on paper. And it seemed to me to be all wrong that there was so much focus only on oral advocacy and no attention being paid to written advocacy where a candidate can shine, and that should be recognized. Then there was also the contributions made by candidates as acting judges. Now, you see, historically, you never had acting judges who weren't silks. That was a legacy from the old regime. But things changed as we started to look for more diverse pools of candidates to draw to the bench. You started getting candidates from the bar who didn't have silk. So now that opened up new possibilities. So you had an irrational situation developing where an acting judge from the bar could write a magnificent judgment, gets reported, where the 2 advocates who argued the case will rely on that judgment in their silk application. But the candidate who's the acting judge who's left and who's gone back to the bar can't rely on the written judgment. And I took that to task and said it's absolutely irrational, so I'm glad to say they've changed it on that score. So there were a number of things, but having said that, the silk application process evidently still has a long way to go, because I'm bitterly disappointed at the results of the 2018 intake where 4 women applied and none got it. So evidently we still have a long way to go.
Thanks, Chief Justice.
Thank you so much, Ms. Stewart. Honorable Nyambi?
Thank you, CJ. Afternoon, Advocate Davis.
Good afternoon.
On the issue raised by JP Hlophe, you have served as a chairperson of the Admission and Membership Committee of the Cape Town Bar Council for almost 5 years. And when he was posing the question, you talk of racism. If you can simplify it, explain it in a way that will understand what's the situation after 25 years, what's happening in that bar council?
I can't speak to the Bar Council. Let me just clarify. My work on the admissions committee was very much administrative. It was to vet the applications for admission as advocates to see that they're qualified in terms of the Admission of Advocates Act. But to get back to so that there wasn't a racist issue there, but to get back to the issue of racism, I think it's most profoundly manifest still in briefing patterns in the profession. That is where I see racism as still an issue. I can't think of anything else to say, but that, of course, is the lifeblood of the advocate, is briefing and briefs. And I think 90% of the work is still going, probably, to white males.
I don't want to think I understand you. When you are referring to racism, we are only referring to briefing patterns only. There's nothing beyond that you can explain.
Well, not that I'm aware of. I can only tell you from my perspective and my perception. So I can't speak to anything else. That is my perception. That is where I perceive racism to still exist. I haven't seen it anywhere else in my daily experience. Remember, I haven't been there 2 years now. I've been at the bench. But in my daily experience, I didn't encounter it, other than the phenomenon of briefing patterns. But I would be open to hear anything to the that if you ask different people, give you different answers. I'm just saying to you, my experience is limited. I'm aware of it in terms of briefing patterns. I don't know that I can speak authoritatively to anything else.
My last question, what's your view about the issue of a politician taking a public platform, criticizing a judge or a judgment?
I don't think that judges and the judiciary are immune from criticism. We live in a constitutional society, and we must expect and be open to criticism. However, I do think that the criticism should be fair. I do think it should be informed. I think it should be measured. And I think that politicians should be responsible and careful about undermining public confidence in the judiciary. So yes, I think there's always room in a constitutional democracy for responsible debate of our judgments, but taking care always not to undermine confidence in the judiciary.
Thank you, CJ.
Thank you, Honorable Nyambi. Commissioner Msomi?
Thank you so much, CJ. Good afternoon.
Good afternoon.
Just 2 questions from me. There's a case that was reported in the Sunday Times over the last I think it was on Sunday, about the composition of the Legal Practice Council in the Western Cape, where a black male was apparently chosen over a black female. And it has caused a lot of consultation there. Do you have any views on that, where the LPC in the Western Cape is challenging what they call the rigidity of the quota system when it comes to the composition of the Legal Practice Council?
I haven't followed the case in depth. I'm vaguely aware of it because I've seen newsletters, but I'm aware that there's a challenge because they feel that it's irrational that a black male was appointed over a black female. I myself have no strong views on the subject. I personally think that it was up to the constitutors to constitute the committee as they saw fit. I don't see any particular problem with the way it was constituted. And I wouldn't support that challenge. But having said that, I don't have a lot of information about the case and I don't have strong views on it.
Thank you. Earlier on, you made reference to your background as a Christian. I'm not sure if this is a fair question to you, but let me pose it. Has that influenced you in any way has it influenced your judicial philosophy in any way, if one has regard to what I would call the differences between conservative judges and liberal judges? Where do you fall within that realm?
I would say that I fall on the liberal to activist side, precisely because of who and what I am. I seek to implement fairness. Let me say at once that I see no conflict between my faith and the values of the Constitution. You're not going to have any difficulties with someone like me having conflicts between their faith and the Constitution, because for me, the one reinforces the other. But I can tell you where my faith does inform my seeking to become a judge, and it is this, is that I perceive it to be a call to service. So I don't know if that answers your question. You're asking how my faith influences me. It influences my obedience to what I perceive as a call to service. I'm not here to seek personal ambition. I'm not here to seek aggrandizement. I'm here to put whatever talents I have to work for the service of my country and its people.
No, thank you so much. Perhaps by way of illustration, have you been able to develop our common law to be in line with our Bill of Rights? Are you able to cite any decision where you pushed boundaries and you basically demonstrated your judicial activism or liberalism, as you put it? Thank you.
Thank you very much for that question. I'm delighted to be able to tell you that yes, I have. I was privileged to have the opportunity to write a judgment just a couple of weeks ago in the matter of AF versus MF. It's a Rule 43 matter, hence I can't give you the names. And a woman was seeking a contribution to legal costs for a divorce. And you will know, Commissioner, that it's a reality of our society that although the laws are neutral, it is 90% of the case that it is women who are coming and asking for a contribution to costs of a divorce because men still predominantly wield the purse strings and control of the family finances. And I was up against authority, old authority. When I say old, I'm talking the 90s, where male judges had written things like, the word contribution to costs means that she can't get all her costs. And I struggled with this and I wrestled with this and I said, no. I said, that is like saying that you need a full tank of petrol to get from point A to point B, but I'm only going to give you half a tank. So what is the result? The car runs out of petrol, it can't get to where it needs to go. And I used that analogy in the judgment. And I said, if there is the resources available, we're not talking about where there's no money, but if the resources are available and the woman has a reasonable need for that money to litigate, she must be given the wherewithal to have equality of arms in litigation. And so I followed a judgment. It was actually a judgment by Acting Justice Donan in our division in '96, who first put out this idea, and I developed it. But I developed it, and I hope now that it'll take off, that this idea that a contribution means you can't get everything you need just doesn't fly in this day and age.
Honorable Clever.
Sorry, CJ, my hand was not up. So you might be confusing me with my colleague on the right. Sure.
Wima. Yes, and then instead of Honorable Dodovu, I said you. Yes. Honorable Mwema.
Thank you, CJ. Good afternoon. What is your understanding of the aspect of the rule of law that suggests that none of the creatures of the Constitution should act outside its scope and powers, and apply that proposition to the latest case that happened in Western Cape, where the Delil case, where Delil, the former mayor of Cape Town, won the case on the basis of the fact that how the body that terminated her membership was constituted. Thank you.
Commissioner, I'm afraid you have me at a disadvantage because I'm not familiar with the case. I would love to be able to answer you, but since I haven't read it, I can't answer you. But if you would like perhaps to just pose your question again, I can try and perhaps answer it on a theoretical level.
The point is that all of us sitting here, we are a creature of our constitution.
Yes.
So therefore, anything that we do must be within the confines of our constitution. If we don't do it, probabilities of our decision being set aside is galore. So can you just expatiate on your understanding of the rule of law?
Yes. Well, it's fundamental to the rule of law that all power must be legally exercised. No power is validly exercised unless it's exercised within the confines of the law. Now, judges, of course, are tasked with interpreting and defining the ambit of legal power. So it's the task of the judiciary to define the ambit of legislative power, executive power, and here's the difficult thing, judges must also define the ambits of their own power. And there's the rub. Who polices the judges? Well, fortunately, we have a hierarchical court structure, appeal courts, ultimately the constitutional court. So if judges get out of hand and overreach themselves, ultimately, hopefully, they get checked at the constitutional court level. But in a nutshell, really, it simply means that all those branches of government have to act within the limits of their legal power, and that implies an understanding of those limits and an acceptance of those limits.
Thank you, Chief Justice.
Thank you so much, Honorable Moima. Honorable Dodovu.
Thank you so much, Chief Justice. Afternoon.
Good afternoon.
Yes. You made a very powerful assertion that your appointment to the bench you will make an indelible contribution by enhancing the performance of the court. In what way, in what practical ways do you think you can do that? And if there are limitations in the current setup, which are those and how you can improve those limitations?
Commissioner, I could never improve anything on my own. As a judge, we are part of a team, and my aspiration is to become part of a team of committed people working to make things better. I've argued that I could, God willing, make a contribution by virtue of my experience, by virtue of my background, my particular talents, my abilities. And I've argued that I could make a contribution because I'm a good team worker and a good team player, and I work well with my colleagues. If I were to be privileged enough to be appointed, I would want to continue working with the Judge President. There's an initiative that I'm very excited about in our court, and that is to bring in young practitioners for training in the High Court. There was a workshop just recently held. The initiative is being spearheaded by Judge Slope and Justice Saldana in the Western Cape. The idea being to bring in young practitioners to demystify the High Court and to show them and give them confidence in High Court litigation. So I see very much, apart from work as a judge, I would want to see my commitment to legal professional education, which I've worked in for 20 years, I would like to see that continue somehow within the confines of the judiciary, because I'm passionate about sharing of transfer of knowledge and skills.
Yes. I must confess that I fell in love with what you said about your upbringing, as well as the fact that you are an activist in nature in terms of how you want to see the situation unfolding. Now, in line with that, may I ask this question? do you subscribe to a notion of expropriation of legal knowledge without compensation?
Absolutely. Absolutely. You had me there.
Yeah, okay, thank you. Thank you very much.
That was quite creative. Advocate Ngozi Thomas, SC.
Thank you. Thank you, Chief Justice. Good afternoon,
Good afternoon.
Ms. Davis.
Good afternoon.
You said something about briefing patterns, suggesting to us that it constitutes an act of racism to brief only white male practitioners. And you then also said to us that you are passionate about legal professional education. Your form tells us that 70% of your practice, your questionnaire, is commercial in nature. Now, as a legal professional education activist, one would expect you to use that 70% of commercial practice that you command as a training ground for these people that you wish to share knowledge with, namely the disadvantaged among us. You and I were in the Constitutional Court, and you were acting in a commercial matter, and you were on your own. So I'm wondering, therefore, in other words, you didn't have a junior, let alone junior white, junior black, junior. Therefore, it makes one wonder, to what extent do you use that 70% of your commercial practice to empower people that are previously disadvantaged as a champion of legal professional education?
Thank you, Commissioner. I'm glad you asked that question because it's an obvious question, and that the matter that I was in the Constitutional Court with you, the Trinity matter, the reality of the situation was that costs were a very, very sore issue. The client was running on empty at that stage. The team that had appeared before me comprised a very senior silk from the Cape Bar and a very senior junior, and they appeared in the Supreme Court of Appeal. And the matter just couldn't bear those rates anymore. I came cheap, and I was willing to work very cheap to have the opportunity to work in the Constitutional Court. So that simply is the answer there. There just wasn't enough money to go around. I certainly didn't make a lot of money on that matter. As to the question of commercial education, I have tried to use my particular expertise to educate, because my work in education from 2007 until 2017 at the Cape Bar has been to participate in the pupillage training program where I lectured on insolvency, which was my field. So I have tried to put my particular skills to practice. But when I said in my form that 70% of my practice was commercial, that was 70% of my little pie. You mustn't confuse me with respect with one of my brethren who commands a huge number of briefs, who's making loads and loads of money. I have had to fight for everything to get where I am at the Cape Bar. I have not been at the top of the pile in terms of number. In fact, in order to get silk, I had to fight against the notion that I didn't have a busy practice. It didn't matter how good I was with what I did have. I was told that I didn't have a busy practice. So the context of when I say I am 70% commercial, it's 70% of my little pie. It's not a big pie, but I'm proud of my pie, and I've done the best I can with my pie.
Well, I guess, Ms. Davis, the question is, what is the percentage of that 70% of your little pie that you've used? So percentage of a percentage of the 70% of your little pie. What is the percentage that you've sort of used to empower those that would have otherwise not access to the work?
Well, as I've given the particulars in my form, in the 2 years before I went to ACT, I involved black juniors in fee-sharing arrangements. I briefed a black junior in a research project, and I also led a black junior where the black junior commanded the fee and I did the leading work pro bono.
And you didn't think that the Trinity matter that served before the Constitutional Court, it being a commercial matter, would have afforded those juniors that you entered into a fee-sharing arrangement with a brilliant opportunity to acquire this skill?
It might well have, but as I say, the difficulty was that I was already working on reduced rates, and then there was the matter of travel. So had I involved a junior from Cape Town, there was a question of then who was going to sponsor their travel costs. The client would absolutely not have been amenable to it. I can assure you I did think of it, and I would have loved to have been able to do so, but it just wasn't an option in that matter.
Thank you, Ms. Davis. Thank you, Chief Justice.
Thank you so much. Advocate nominee C.
Thank you, Chief Justice. Good afternoon, Ms. Davis.
Good afternoon.
Just to piggyback on the last question to you, what makes you think that had you approached those black juniors, they would not have been able to pay for traveling and for their accommodation?
I'll be honest with you, it didn't occur to me to think that somebody might be willing to do that. I mean, I'm so alive in the Cape Bar to the difficult time that juniors have that I didn't think that somebody would be able to throw money at a plane ticket to Joburg and a night in a hotel. I'm sorry if that was a mistake on my part. But I can only emphasize that I was myself working on very, very limited rates in that matter. It was not a money spinner for me. I have never made big money at the bar. I say that with no apology. I've done an immense amount of pro bono work. I've done an immense amount of amicus curiae work. I'm not there to make money. I never have been. And
I didn't, sorry, Ms. Davis, that was not my question really. But the point that I'm making is when you are keen to assist, you make inquiries. That's the point that I'm making. If you are keen to assist and you know that every junior would love an opportunity to be a junior to a silk at the Concord and would make means of trying to get there, because all you have to say is that, come help me on this brief, I don't have money, I'm not gonna pay you, you will find them. We find them, all right? We find them when we want them, and all I'm saying to you is that when you make the inquiries, you do get responses. But
well,
the point...
I'm sorry if I made a mistake then, but I myself would have, it would have appalled me to consider asking somebody to come on board for no money. I mean, I just, it wouldn't have occurred to me to do that.
No.
And the only reason I didn't offer a fee sharing arrangement was that my fee was so limited. So that's all I can say in my defense. If I made a mistake, I'm sorry.
No. I don't take it as a mistake. I just want to understand your thinking. You see, I want to understand that the type of a person that you are. You've told us who you are. That's basically what I'm exploring with you.
Well, let me say it to you this way. I'm very sensitive to not exploiting people. So it would have been an anathema to me to go to somebody to say, you know, if you want to come for the experience, you can come, but you're going to have to pay for your own plane ticket, and you're going to not get a fee. I would have thought that was the wrong thing of me to do. So that's where I'm coming from.
Okay.
I would have thought that was insulting.
All right. Seeing that you don't want to let go of this point, let me ask you this question. Why didn't you look for another senior, junior, black or white for that matter, who could go with you, who could afford to pay for accommodation, who could afford to go through the brief, and even if they were not going to be paid, because they know that what they want is to get the knowledge that's in the brief, and take them with you to the Constitutional Court. We're not talking about the poor black juniors. We're talking about juniors that you could have taken.
Well, it wouldn't have occurred to me because my understanding of my colleagues is that they're also mercenary, that it didn't occur to me that any would be interested if they weren't being paid. That's my answer.
Okay, thank you. Now, there's you were asked a question when you appeared.
That's the third one, but there's
that the third chair?
Yes,
You're-
but it's okay.
I even said chair. That's how shocked I am.
I'm chair. It is okay. It's just that I've realized colleagues just continue and continue. Take it, but it's all right.
Thank you, Chief Justice. I promise this is the last one. Thank you. When you were interviewed in 2013, you responded one of the questions that you were asked by the Chief Justice. It appears in the transcript. If you don't mind, I'll just read it to save time. The Chief Justice asked you a question. So, as a woman, what are you doing to contribute to finding solution to the problem of what you have done? That is all that he was asking. And why are you not participating? Where is your hand in efforts designed to bring about the change that is so desperately needed? He is not really accusing you of anything or putting you in any category, but that is the information that he sought to solicit from you. And your answer was, well, I think the answer that I would like to make there is that you will see from my application, and I have for many, many years been involved in legal education, and while I educated both males and females alike, I always had a special place in my heart and would offer special words of encouragement to the female candidates. Now, can you just tell me what do you, if there's a female advocate that comes to you, and that female advocate says, I'm thinking of leaving practice because I am not making money, what type of words of encouragement do you offer that would make that person to stay?
Well, that has never happened to me, but if it did, I would sit down with the person and I would chat with them and I would ask questions and find out and try and get to grips with what is the problem, what is going on, what are the issues, and I would try and see if I could find a solution with her. And I would do whatever I could. If I had work to share, I would pass along. I'd talk to people. As I say, I'm talking about how I would handle it because it has never happened to me. But that is how I would deal with it. I would look to find an active solution to meet that person's individual problem, because there are many different reasons why individuals don't make it at the bar, and you have to diagnose each individual's problem.
Thank you, Chief Justice.
Thank you so much. The Honorable Deputy Chair of the NCOP.
Thank you, Honorable Chief Justice. Good afternoon, Ms. Davis.
Good afternoon.
I was looking into your different areas of where you have been able to do some issues, some work, and also as an opinion maker. I was thinking to ask you this question. Firstly, I see that you have presented a paper, United in Our Diversity, the role of forgiveness in the transformation of South African society. With regards to that one, I would just love to understand what is the general gist of the paper that you have presented, but also taken in regards with the issues that since I've moved to Cape Town, I've experienced that there is a lot of farm evictions in the Western Cape particularly. And I was just thinking, if you put the areas together, but also in terms of your pro bono work that you have been doing, particularly in the case of Ms. Chabe, as I have observed it, I would love to know what is your view with regards to the issue that, particularly in the jurisdiction where you are serving, it seems as if ESTA legislation is not really enforced. It seems as if people are very much helpless with regards to the fact that they are being evicted like nobody's business. So I just, within that context, if you can just espouse your view. Thank you.
Well, okay, if I can answer two questions separately. Briefly, the paper about the role of forgiveness, it was a metaphoric piece. It was for the Ad Verum literary seminar about the role of the interconnection of law and society. And what I did in the paper was sketch, because these were young students who were probably all born in 1994 and later. And so I was sketching for them the background of apartheid and then the idea of the Constitution as a bridge from the past to the future and where we've come from and where we're going. And the paper was really then a reflection on the importance of forgiveness in our society, but it was a reflection on what is forgiveness. And my favorite piece in the paper is where I say, forgiveness is not a Kodak moment frozen in time. It's a daily act of will to move forward in an act and state of forgiveness. And the other major piece in the paper is that for there to be forgiveness, it requires a state of penitence, and that I personally think that we still have a long way to go in this country to see a state of penitence in the perpetrators and beneficiaries of apartheid that will lead to a state of forgiveness. Anyway, that's about the paper. Don't get me started because I'll go on all day about it. But then to your other question about Esther. Esther cases get dealt with in the land claims court, so I can't really give you a meaningful response on that score, because in the High Court we don't deal with Esther. We deal with other evictions, but they're not the Esther type. So I'm sorry, but I can't really help you there. If there's something else I can answer, I'll...
There was an issue that people within the area of the city have been evicted. But what I generally want to establish,
yes,
is what is your view around what is happening, particularly how can the judiciary assist in making sure that really there is a kind of a, particularly if I look at how you approach your work, let me put it like that, in terms of what I've seen in the pro bono side of you. So that is why I would have loved to understand what is your view, what can be done, how can the judiciary assist with regards to all these issues?
Well, generally, with regard to evictions, we, in terms of applying the PIE Act, the Prevention of Illegal Eviction Act, there, of course, a judge has tremendous scope for protection of human rights, because a judge has a discretion to refuse an eviction if it would not be fair and equitable in all the circumstances. And there are many circumstances you look at to get the whole picture. And there are creative things you can do, like ordering mediation and engagement and getting the city involved to make sure that there are solutions found to ensure that people aren't going to be left homeless by an eviction order. And speaking personally, I would be very loath to ever grant an eviction order without making sure that there's a safety net in place and that people are not going to be left homeless by it. And I never have.
Thank you so much, Honorable Chair of the Portfolio Committee.
Thank you very much. Thank you very much, Chief Justice. Good afternoon, Advocate Davis.
Good afternoon.
What do you think will be the impact of the fourth industrial revolution on the legal profession, especially with regards to opinion writing and legal research, and the work that is being done by your first year bar advocates that have just entered the profession? To what an extent will the fourth industrial revolution impact on them?
I'm afraid I'm going to have to ask you to speak up. I didn't hear a lot of your question, so if I could ask you to repeat, please.
Okay. What do you think will be the impact of the fourth industrial revolution on the legal profession, especially with regard to opinion writing, legal research, and the impact on the first-year advocates?
The first thing, the fourth, did you say the fourth? The fourth industrial revolution. You mean technology? You want to know the impact of the fourth industrial revolution on opinion writing and... Well, I think we're seeing it happening already. To me, what immediately comes to mind is an explosion of access to information. It's much easier to research, so it's much easier to generate quality research in a much quicker period of time. I know from personal experience that one can, at the click of a button on one's computer, you can access legal materials all around the world and refer to them. So I suppose what that means for us is that the world is becoming a global village, that we can draw on best practices, best ideas, best traditions from all around the world because we have access to that information. That would be one thought that would occur to my mind. Bearing in mind, of course, that we must always take care to root it in our own homegrown culture. But yes, I would say we can take legal reasoning, legal authority from all over the world and use that research in our work. So effectively, it's going to enhance quality. That's what I would say.
I argue that big firms are starting not to employ law graduates to do your low-level work because they are just using advanced artificial intelligence to do that work.
Yes, well, that would be a negative aspect. That would be a pity. But at the end of the day, yes, you can get stuff at the click of a button, but it's a human brain that has to decide how to deploy that information. So I don't think you can write off lawyers just yet.
The last one.
That's the third one now, Chair.
Okay.
Yes. You feel strongly about it?
No, let me ask it, Chief Justice. To what an extent have you taken the initiative to understand the people of the Western Cape whose judgment you will be impacting upon? Have you been to Guguletu, to Khayelitsha? Do you know how those people live? To Mitchell's Plain in Manenberg?
I have been to Khayelitsha. It was some time ago. And in fact, I remember it very well. I went at the invitation of a lady who worked as a cleaner at the firm where I was articled and practicing at the time. And we formed an unlikely friendship, and she invited me to go to the opening of her church in Khayelitsha. So I have been there. I've also been there on inspections in criminal trials. So I have some idea. Can I do more to understand? Yes. Am I willing to do more to understand? Yes. Why haven't I done more? It's such a simple thing. You ask me, have I been? And I say, yes, I've been once or twice. I don't really know why. One lives in a particular place, one goes to work, one does one's thing. I don't really have a good reason for why I haven't been in any of those places. But it's not through any unwillingness to understand. And I also think that one gets to understand people by listening to them. And when you've sat as a judge for some years, as I have now, you get to understand a lot through listening to the evidence in court. You get to understand people. And reading records, reading transcripts of magistrates' court proceedings. Of course, it's important to go to places to understand, but you can also develop a huge understanding through listening and reading, and that I've tried to do. Oh, I should also add that I'm trying to broaden my cultural horizons by taking Xhosa lessons, and the lessons are more than just language, they're also cultural lessons. Ndiyazama ukufunda isiXhosa.
Commissioner Sigoga.
Thank you, CJ. Afternoon, Council, how are you?
Good afternoon.
I do not have much with you, but I'm particularly touched by the criticism leveled against you in the media in respect of the Waterloo House Girls' School. I want to hear from you where the girls complained about their superintendent, that they were touched inappropriately, and a K word was used against them, and you found that the superintendent did not contravene any law. So I want to understand what does that mean. And in the conclusion, you indicated that they had a legitimate cause for complaint. So I want to understand, how will they have a legitimate cause of complaint when the other person did not contravene any law? Thank you.
Thank you for giving me the chance to explain that. I can see why it might be perplexing. On the facts, I interviewed a broad range of learners, some of them being the complaining learners and others not being complaining learners, and it was diverse across all races that I interviewed. Interviewed the matron and interviewed a number of staff members and her assistant matrons. And it became very, very clear on the facts. Even one of the matron's detractors, one of her sub-matrons who didn't get on with her, even she said that the girls went too far when they accused her of abuse. Because what was at the bottom of it was that the matron liked to hug girls. She was a sort of affectionate, motherly person. And the difficulty was that some teenage girls like being hugged and some don't, and she didn't get the hint. So, you know, the slur of physical abuse was just completely unfounded. But it was definitely insensitive of her. You know, you need to be able to pick up on the body language if somebody is not enjoying it, if you give them a hug, and you should back off, and she didn't do that. So that was the one issue. The K-word issue was a supreme example of somebody who just did not have a clue about being sensitive. Turned out that the context of that was that she was lecturing the girls against the evils of a particular music channel on TV that they watch, which features rap music, which has a lot of swearing in it and a lot of the use of the American N-word. And the matron took umbrage at this, and she was lecturing the girls and saying to them, "It is as if I were to say to you," and then she said the word, but she didn't just say it once, she said it several times, and it was a bit over the top. And it was gratuitous. You know, the point is, she could have made the point. She could have explained to the girls that this was demeaning and dehumanizing. She didn't have to go and use the word in the way she did, but that was the factual context of it. She certainly didn't have an intention to be racially derogatory. So my finding at the end of the day was that this was a person who really had no ill will, but she didn't have a clue. She didn't have racial sensitivity. She wasn't in touch with the issues. And the girls also had legitimate cause for complaint because she was uneven in her application of discipline, not across racial lines, but just generally uneven. You know, something will be okay for this one, but it's not okay for that one. If you know anything about teenage girls in a hostel, you will know you've got to treat them all the same or else they're going to be unhappy. And she just didn't do that. And so that's why one of the recommendations I came up with was that there had to be a uniform code of conduct and code of discipline applied uniformly to everybody so everyone knew where they stood. So at the end of the day, the recommendation was that she be terminated, but she had decided to go anyway, and that they appoint somebody who better represented the demographic and language composition of the hostel.
Thank you, CJ.
Thank you so much, sir. Advocate Davis, you're excused, ma'am.
Thank you, Chief Justice. Thank you,
so
everybody.
much.